particular unit. Now, it is true that the burden is upon the people to, not the TVB, to prove their case by clear and convincing evidence. However, she also states, Ms. Green, that we're getting opportunity to cross-examine. That is the whole issue. There is no opportunity to cross-examine unless the respondent has the ability to prepare properly through the radar manual. Now, as far as the procedures of appeal and everything, I submit that the court should take into consideration that the average layman who comes into the Traffic Violation Bureau is not prepared to take appeals. He comes in and he pleads guilty, and that's what's been happening. Expediency has been replaced by TVB for due process. You can't say because of the amount of people and accidents that have taken place, therefore, anybody, let's have a Red Star chamber, we stamp him, he comes in with a ticket, he's guilty. He's entitled to due process before he's found guilty.
Thank you very much, Mr. Breslauer.
Thank you.
Blye versus Mapstoa.
Ready, Corp, please.
Mr. Crowitz, I've looked through this case. I'm still trying to find the hidden point of law here. I think that everyone would concede that Mapstoa certainly has some duty, but isn't this basically a conflict with respect to the facts?
Exactly, Your Honor. May it please the Court, before I commence, I would also like to reserve some time to rebut the arguments of Mapstoa.
All right, now, going to the facts of this case.
Your Honor, I believe that the Appellate Division, in expanding the duty, which they clearly did from Zuckerman to Blye, it's now settled, at least in the first department, that they have a duty to provide a safe place to board a bus to a prospective passenger. But now we go to the next issue. The court basically usurped entirely the factual testimony, the evidence, everything that went on at the trial, that the jury heard, that the jury considered, that the trial court considered. In fact, that the trial court asked for memoranda post-trial and considered those and came back and affirmed the jury verdict.
But why shouldn't they on the facts of this particular case? Because even though they might assume there was a duty, assuming that for the question, the duty certainly isn't for the bus driver to go out of the bus and take the passenger by the hand and lead. Here, this passenger walks diagonally into a tree well and falls down. If the passenger boarded the bus directly right through the door, there would have been no accident.
Your Honor, if I may state, based upon the testimony at the trial, the passenger, from the vantage point that she had on the street, on the sidewalk rather, as to where the bus stopped, was walking in a diagonal line directly to the doors. Now,
well, she had another clear path, though, to the door of the bus.
yes, Your Honor, but it was foreseeable that based upon the place that the bus stopped, it was foreseeable, without the bus driver having to get out of the bus and survey the sidewalk, so to speak, that it was foreseeable that since people do not queue up, as they do in England, to get on a bus in New York City, because they'll find themselves waiting with the bus doors closed in their face, that they get to the bus as expeditiously and as quickly as possible. That
Well, is foreseeability the test, or is one clear path the test?
I think foreseeability is one of the tests that the majority below ignored. They mentioned it and then ignored it. What they did was they created a matter of law as to what this woman did, which was a question of fact. The jury clearly heard how she got on that bus, and in fact asked that that information be re-read to them before reaching their verdict. They came back with a 15% contributory liability against Mrs. Blye. So they clearly did not rubber stamp liability against Mapstoa, but determined that because of where she was standing, vis-a-vis where the bus was, that it was foreseeable that she could have walked, and in fact did walk, through the tree well. The fact is that the rest of the bus stop was empty. and the bus could have pulled up well beyond this tree well, which would have changed the path Mrs. Blye would have walked, because the bus would have been farther in front of her, and that she would have not had to walk through the tree well at all. The fact is that the foreseeability issue is created because of where the bus stops. You don't stop a bus in front of an area which is clearly a dangerous condition.
Well, is it your contention then that the bus driver has a duty to learn the condition of the sidewalk alongside which the bus is pulled?
Our theory, Your Honor, is that if there's a condition to be seen, which a 3-foot square tree well is definitely not an obscure obstruction, and if in fact, and because it is a factual issue and the jury heard the facts, if there's the rest of the bus stop free and clear to be used to board passengers, yes, indeed, the bus driver has to exercise some type of discretion.
Well, there was a portion of the bus stop free and clear. Your complaint is that he didn't leave enough of it free and clear.
He did not pull up far enough, Your Honor.
Yes, but there was a portion of the bus stop free and clear to enter the bus, was there not?
I'm not understanding your question. To Mrs. Blye, the direct path to traverse was through the tree well.
Well, it was a path she traversed because she chose to walk right through the tree well instead of around it, but there was an open path for the bus.
I concede that if she had walked around the tree well and taken a more circuitous route, yes, indeed, she would have avoided the tree well. But the question here is the foreseeability of putting an obstruction between where she was and where the bus door was, and that's the path she took. We have hindsight to dissect exactly how many steps she took, how she was thinking. This wasn't happening at the time. Mrs. Blye was interested in going from where she was standing into the bus. The path she took, unfortunately, resulted in a very serious injury. But the question is that foreseeability, which is a factual issue in its basis, was completely ignored by the majority, in fact picked up heavily by the dissent, because the appellate division created a legal certitude out of what is clearly a factual situation. The jury might as well have not even been sitting in this case. They heard every possible argument and every possible question, both on direct and cross, regarding how she got to that bus door. And they didn't decide that it was 100%, obviously she should have walked around, and they didn't dissect it that way, but found that she was reasonable, and that her path was reasonable, and that the defendant was responsible. And they also found that the city was not. And we don't contest that, because if you're going to use the fact that the jury has the obligation to decide the facts, then you have to put up with the jury decision whether those facts fall in your favor or not. The defendant decides that because they didn't convince the jury that this is not their responsibility, because they did not object to the charge that they have a duty to provide a safe place to board, that they should come to this tribunal for this court to reverse the decision, ultimately, to determine that Mrs. Blye shouldn't have walked that way. I will save the rest of my argument for rebuttal. Thank you.
Thank you very much, Mr. Kravitz.
Your Honor, nothing that the appellate division in this case did usurp the jury's fact-finding function. There was very little dispute about the facts. The only witness to the accident was Mrs. Blye, and the appellate division took her testimony, her measurements, and her own concession that she could easily have walked around the tree well to get to the front doors of the bus as the basis for its decision to throw out the verdict.
There is some duty here, is there not?
Assuming there is, and the appellate division has so held, although there are older cases that are arguably inconsistent with that.
Well, if the bus here had parked in such a way as there was no way of getting this door except going through the tree well, there'd be some obligation.
Yes,
If the bus stopped in front of a landmine and the
True,
passenger had to walk over the
But
landmine.
that's not the case here. What you have is a situation...
Excuse me, Counselor,
Yes.
excuse me, you don't have to assume it. If you didn't accept to the charge, it's the law of the case that there's a duty, isn't there?
Well, there was some exception to the charge. I would dispute my adversary on that point. I'd point the court to pages 452 to 455 of the record. But let's deal with the question of whether the duty was discharged. We've got a situation where the woman is 10 feet back of the curb. The tree well, let's assume the lectern is the tree well. Bus stops 2 feet away. There are people with her. who had absolutely no problem of simply walking the bus's front doors. Now, what does Mrs. Blye do, according to her own testimony? For some strange reason, like an iron drawn by a magnet, she simply walks directly into a cobblestone at the left lower corner. Now, nothing that the driver did compelled her to take that route. It was a strange route, it was circuitous, it wasn't direct, and if we assume that Mapstow does owe a duty, the driver did all he could. Now, let's assume the driver stopped a little further up. If the court examines the pictures, the court will also know that there's a light pole right at the edge of the curb. Let's assume that the bus had pulled up 2 feet beyond the light pole, and Mrs. Blye simply continues walking and walks into the light pole. Would any court say that Mapstow violated its duty when all the potential pedestrian had to do was walk around that? And that's pretty much what happened here. There was no dispute about the facts. Mrs. Blye could simply have walked around the obstruction. She wasn't compelled to choose the route she did. She could have guided her own path. For some strange reason, she chose the path she did.
How much distance was left ahead of the tree and to still be within the bus stop?
According to the pictures, a good deal. A good deal. But in any event,
If you assume the duty that you've been describing to us in wandering around, which is very impressive before a jury, but I'm concerned, once you assume the duty, are you not conceding factual permutations
to a
which are
large
not,
extent.
what's the question of
Well,
law for us then?
the question of law is whether under the unique facts of this case, where there is conceitedly, again, with no conflict of the testimony, an easy and safe way of getting to the front doors of the bus, whether Mapstow violated that duty. Often, it will be a question of fact for the jury. But this case, to a large extent, is sui generis. There simply was an easy way for the plaintiff.
Whenever I hear unique facts or sui generis, I think that maybe there isn't a question of law for this court to review and that it was a factual dispute properly resolved by the jury under the usual rules of such matters.
Again, there was only one inference. There is no explanation for the path plaintiff took. There were other people with her who were within a couple of feet of her, according to her own testimony, who simply walked to the bus's front doors. It doesn't strain any fundamental principle, fact-finding, jury fact-finding, to say that the appellate division correctly decided that under these facts, Mapstow discharged its duty to plaintiff, and that accordingly, the suit was properly dismissed.
Thank you very much. Ms. Kravitz?
May it please the court, again, the creation of the matter of law from a set of facts is a very unique situation, which this court, in many, many cases, dating back to the 1940s, which are in the briefs, has determined clearly factual considerations for the jury, and specifically foreseeability problems because of the inferences that can be drawn would certainly be considered factual determinations. The opinion below states that these facts, in this case, are not susceptible to varying inferences and just broad brushes the fact that there are no facts to consider and therefore it's a matter of law. We seriously dispute and debate that particular decision. The fact is that Mrs. Blye was not waiting with the crowd but was farther back from the bus stop, and the fact is that the people who got on the bus did so, thank you that they were not injured as well, based upon where the bus was stopping. If someone had walked with her, they too would have fallen on the cobblestone. We're lucky that she was not injured, no one else was injured, and that Mrs. Blye submits to this court that the initial decision of the jury should be upheld, and that since it's a factual determination, the verdict should be reinstated in her favor. Thank you very much for your time.
Thank you very much, Mr. Kravitz. Pappa versus New York Telephone Company.
Ready at the court, please.
Mr. Laidlaw?
Yes, sir. Good afternoon. There are two issues to this appeal concerning my client, Joseph Pappa, who found himself completely left out of the phone book in Syracuse back in 1983. due to the phone company's failure to print 7 ads that he had ordered that year. And those two issues are the unconscionability of paragraph 7, which is buried in the fine print on the back of their contract form.
That contract, if it's held to be valid and not unconscionable, as you say, would bar this action.
Absolutely. Yes, sir.
As would Hamilton, would it, as a precedent?
Some courts have said so, yes. We find Hamilton to be distinguishable.
On what basis?
Aha, glad you asked that question. In 1930, this court was confronted with a very real problem faced by New York Telephone Company as a public utility providing phone service in New York State. And that is, they had this adjunct function of putting out a directory. And they were subject to being sued left and right if they made any kind of a little boo-boo in that phone book, misprinting a phone number or leaving it out, in the ordinary free listings that their subscribers are entitled to as part of their basic service. So the court, and very properly so, ruled that the phone company, since printing a directory was not their main line of work, providing phone service is, they said that the New York Telephone could limit its liability with a reasonable clause in its service contract, so long as it did not exempt them from gross negligence or willful misconduct. But the clause that they approved in Hamilton is not paragraph 10 that we are confronted with in this advertising contract, and we feel there is a great distinction between ordinary listings, which every subscriber is entitled to as part of his basic service. These are the light-face type, alphabetical in the white pages, and also light-face type and by category in the yellow pages if you're a business subscriber. Those are listings. They are regulated by the Public Service Commission. There is a tariff that very clearly states that phone company is not liable for errors and omissions in that ordinary phone book. But today, Mr. Pappa, my client, he is hurt to some great extent, he claims, by the omission of advertising. And it is our position that advertising is an entirely distinct operation of this phone company than providing telephone service. It's a separate, private enterprise. It's not regulated by the Public Service Commission.
As I read the exclusion in Section 10, as I read the exclusion in Section 10, it is really not a limitation of liability. As you read it, it seems to say there's no contract, there's no acceptance by the telephone company until the advertising actually appears. And if it doesn't appear, that's deemed to be a rejection, and therefore, the position would be, I gather, that there's no contract at all. Is that the way you read it?
That's exactly what it says, Judge Hancock, and that's why it is so grossly unconscionable that they can provide in this fine print form that if we mess up, if we leave your ads out, we reject you. You're rejected. Go away. We don't want to see you anymore.
Well, my question was much the same as Judge Hancock's. When your opponent's first point in his brief is that there never was any contract at all, that they took an order from you and they didn't fulfill the order, and if anything, it was a unilateral contract that wasn't performed.
I appreciate your question. That is definitely another facet of the unconscionability, sir.
Isn't there much merit to that point?
I consider that as another facet. We did not brief that point. It's a well-raised point. It's another facet of the overall unconscionability of paragraph 10 that can result in a man losing $112,000 in profits and have the phone company say, we wash our hands
Well,
of
they didn't
you.
violate any promise to you if there wasn't any contract.
That most courts have viewed this as a contract, but I appreciate the point that they've raised, and I say it's another facet of the overall unconscionability of paragraph 10. And it's not a limitation of liability provision. If you look at it carefully, it says our liability is limited to a refund of what you would pay for your missing advertising. Well, people don't pay for missing advertising. And
Mr. Laidlaw, you indicated you liked the first question. I'll try one maybe you won't like as much. In terms of distinguishing Hamilton, in this day and age where you have a multiplicity of directories now since deregulation, doesn't that affect the unconscionability argument, assuming you get past the contract, and doesn't that give an a fortiori lift to the Hamilton precedent?
It possibly. 1983, the year that Mr. Pappa was left out of the book, was the last year before the breakup of the AT&T system, and believe me, this was the only directory in the Syracuse area. There are today competing directories in Syracuse. I don't think much of them. I don't think people use them, but that has crept into the area.
Thank you very much.
Thank you,
Laidlaw.
sir.
Mr. O'Neill?
Thank you, Your Honor. Basically, our first point was alluded to by the court in its questioning, and that is, it seems to us that the plaintiff has to have a theory based on existing precedent in order to sustain his cause of action. And the instrument that he signed was labeled an order for directory representation. The word order was used throughout the body of the face page and the reverse page. The bottom, just above where the plaintiff, Joseph Pappa, signed his name, that appeared the language in large capitals, clearly legible capitals, that subject to the terms and conditions on the reverse side hereof, which the undersigned has read. And above that, the words applicant hereby requests that the New York Telephone Company publish. On the reverse side, while counsel has alluded to the fact that the print was small, now the copy in the record is clearly illegible, but the exhibits which the court have on file, exhibits 17 and 18, are legible. There was never any claim made by Joseph Pappa that he couldn't read it. The only thing he said in the course of his conversation, he glanced at the small print, but he allegedly talked to the sales representative, and the sales representative supposedly said, in response to Mr. Pappa's question, whether or not you read it isn't significant. You have to sign it in order to get the ad published. That was
As I read it, and as I understand your argument, there's really no promissory obligation undertaken by the telephone company in receiving money pursuant to this order, other than returning that portion of the money received, which might represent the advertising which did not appear.
That's basically our
Really,
position.
all that they're obligated to do is
Well-
return money if they don't
Because
print
of
the advertising.
that essentially is it, Your Honor, because of the fact that throughout central New York, there were 100,000 some transactions throughout the entire state, perhaps millions of transactions. The very nature of the business is such that some errors by some clerical personnel are virtually inevitable every year. That for that reason, the rule in Hamilton arose, and this is why, in a sense, when the salesman talked to Mr. Pappa, it was an invitation for an offer. And this is analogous, it seems to us, as an offer and acceptance where the acceptance did not take place. If the contract had been formed, it might be characterized as a unilateral contract. But there's no evidence before Judge Hurlburt, a special term, that there was any reliance upon an unequivocal guarantee of publication on the part of the telephone company. Also, when the telephone company receives these requests for ads, they have to screen them because some ads are perhaps scandalous, some ads may have language that is improper, and so they have to have some kind of a safeguard. And basically...
But they do that, don't they, before they, or closely after they accept the money?
I don't know myself, and the record is silent as to the actual time sequence involved.
But I mean, if an order were not to be accepted because
That's
it
true.
was scandalous or something,
I would imagine that as soon as
they wouldn't take the money.
I would think that's true, Judge, that probably if someone, obviously if the salesman saw it, but many times, the salesman has no authority by the terms of the agreement. That's Reuben Donnelley's salesman. They have no authority over whether to accept or reject, and that's one of the basic positions that we take. Counsel has pointed out that this aspect of the activities of New York Telephone Company is not subject to regulation by the Public Service Commission, except that they cannot discriminate. It is submitted that the utility has the right to do business under terms that they think are reasonably favorable in light of the factual nature of the business, and I think that's important. This provision was not used as a sword to hurt anybody. It was a shield, and I think it was a reasonable shield in light of the type of business activity.
Obviously, if this were written the other way, we take your money, and this is the advertising we're going to give you for a certain period of time.
Mm-hmm.
If performance were not rendered, there would be liability.
If they
Ordinarily, it would be a breach of a contract to perform.
if they publish the ad, but I think
No, I mean, if it were written as a promise,
yes, if it were written as a bilateral contract,
Right.
yes, then
and
it's a different
obviously
matter.
you couldn't exempt the telephone company for its own breach of contract in that situation.
Yes.
But it's written another way so that that result is obtained by a
This is-
series of unilateral contracts. Really, that's what we're talking about.
I think it's somewhat analogous to, really, this is advertising, and I think it was a request for advertising. Whether you advertise in a newspaper, whether you advertise in the Shopper's Guide or on the radio, it was a request, and I think any advertiser has the right to have conditions upon which the advertisement will be published, and this essentially is what we have here. And the second point I'd like to make is that Hamilton was good law in 1930, decided by a unanimous court. It's been in existence for some 58 years. It's been followed by the lower courts. The legislature has never disturbed Hamilton, never challenged it in any way. The logic of Hamilton, Judge O'Brien said that in a rush of publications, hundreds of thousands of decisions have to be made, and some mistakes may well happen. And in the public interest, if we don't do this, the alternative is to have a new breed of lawsuits which someone will pay for, and it will create a body of law which really is not founded upon existing concepts of law.
Thank you very much, Mr. O'Neill. People versus Frank Oglesby.
Ready.
Good afternoon.
Good afternoon. Yes, Ms. Worley.
I'd like to reserve 2 minutes for rebuttal.
Fine, if you find it necessary. Ms. Worley, is there a preservation problem on this issue?
No, Your Honor, there's not. The defendant asked for a Sandoval ruling, and that was what was denied him. This is not one of those cases where the court gives a partial ruling and the defendant doesn't accept from the ruling. He wanted a ruling, he didn't get it. Therefore, the trial court was alerted to this issue.
Well, here, Mr. Fraser, that was the district attorney?
Yes, Your Honor.
Fraser says before we actually begin the trial, begin with the opening statements, Your Honor had indicated yesterday that in order to make a determination regarding Sandoval, you wanted to see the defendant's record.
Yes.
The court then goes on to say, well, why should I make the ruling? I don't think a Sandoval is necessary when you're trying it by a judge. Fraser says, then I'll proceed with my opening, Your Honor. Then the defendant's counsel says, before we begin, how are you going to treat the prior record of the defendant? The judge then says how he's going to do it, and Dorfman then says, I'm just thinking in terms of the record itself, though. The court then goes on to explain in great detail how he's going to do it, and then Dorfman says, right, Judge, and they go ahead. I don't see any objection, any insistence on a ruling, anything of the sort.
Well, he did raise it. He did raise the issue. He did request the ruling. When the defense counsel says right, it seems to be that what he's saying right is when the judge says, well, look, if he doesn't take the stand, it's not going to make any difference. And that the defense counsel was agreeing with that proposition. If defendant did not take the stand for other reasons, then the question of the Sandoval ruling filed the case. I think all he was doing was agreeing to that proposition. But the issue was raised. Defense counsel did request to know how the court was going to do this.
Could you give me
this
the
ruling.
page reference where he requests, when he makes the specific requests, and then it's denied?
He does ask the court how it's going to treat the court's...
The court then says how it's going to do it, but he doesn't object to that.
He made a pretrial motion for a Sandoval.
Before there was an election to waive the jury, did he ever request a Sandoval hearing after he decided to proceed by way of a non-jury trial?
Nothing other than what Judge Walker just cited, but I think if the prosecutor hadn't raised the issue, defense counsel would have raised the issue. Defendant never withdrew his Sandoval motion, never withdrew the notion that he wanted a ruling. The fact that he then went on and said, how are you going to treat the record then, I think showed that he did want to know how the
Is
court was
there
going to
anything
treat
to
the record.
indicate his dissatisfaction with the court's indicated manner in which it would treat the record?
Because after the court gave its initial answer about saying, I don't want to make this ruling now, I don't think I have to make this ruling now, he then went on and said, but how are you going to treat the record, Your
And
Honor?
then
Give
the
me a
court,
clue.
and then the court made its ruling. It told him how he's going to treat the record.
But the purpose of preservation is to raise the issue to the trial court's attention, and this is what it was raised to the trial court's attention. He did request a ruling,
And then
but
the
did
trial
not. You
court-
don't have to make an exception.
For all the trial court knew at that point, his proposed way of handling the record was satisfactory to the defendant. And for all we know from this record, we may conclude it was satisfactory to him.
The court's ruling was an absolute rejection of what defendant wanted. Defendant wanted a pretrial ruling. That was denied him. This isn't like a Sandoval case where the court gives a partial ruling, letting in some, not letting in others. And if the defendant doesn't say anything, it's presumed that they've sort of waived an objection. He wanted a ruling, he got a ruling. He wanted to have a ruling, and he didn't get any ruling whatsoever. That's why he then went on and said, well, how are you going to treat the record if that's what you're going to say? That's why we believe the issue is to be preserved. The trial court did not act improperly when it declined to issue a Sandoval ruling because a Sandoval ruling doesn't serve any purpose in a bench trial. The purpose of a Sandoval ruling is to eliminate the risk that a trier of fact will use evidence of defense criminal record improperly. As this court recently held in People v. Moreno, trial courts are capable of distinguishing the probative value versus the prejudicial effect and of properly applying the standard for weighing this kind of evidence. Because there's no risk of impermissible prejudice, a Sandoval ruling is unnecessary.
Do you think there is a material distinction then between the jury trial and the non-jury trial in terms of Sandoval?
Yes, Your Honor, because a Sandoval ruling is to eliminate the risk of impermissible prejudice. A defendant doesn't have a general right to a pretrial ruling on the admissibility of all the people's impeachment evidence. They don't have a right to a pretrial ruling on the admissibility of prior inconsistent statements or any other kind of impeachment evidence. The only reason why prior bad acts and prior crimes are singled out is because of that unusual risk that a jury will disregard limiting instructions and will use the evidence improperly. That risk just doesn't arise in a bench trial. In addition, there's no reason to think that it arose in this case. The court said that it was capable of weighing this evidence properly. It said that it would take defendant's record for what it's worth, but I don't pay too much mind to that sort of thing, not to the extent that a jury will, and I'll charge myself accordingly. In fact, the court then went on to explain how it made Sandoval rulings, and it very specifically indicated that it wouldn't take into account weapon convictions and assault convictions, because the court said those don't show anything about credibility. Unbeknownst to the court, those were the kinds of convictions defendant had. So the defendant knew that that the court wasn't going to be prejudiced in this case. Consequently, it wasn't error for the trial court to decline deciding that issue before trial. As to the sentencing issue, a defendant who illegally possesses a gun should face the possible, potentially additional time when he then uses that illegally possessed gun to shoot someone and causing physical injury. Penal Law 7025 Subdivision 2 doesn't prohibit that. These crimes were not committed through a single act. The act of holding on to a gun, exercising dominion and control by holding on to it is a different act than actually pulling the trigger, firing, and causing physical injury. In addition, neither crime is a material element of the other. Assault is not an element of possession, very clearly. Similarly, possession is not an element of assault. The best example of that is a case where a perpetrator pushes somebody in front of a subway train. A person that pushes somebody in front of a subway train causes physical injury by means of a dangerous instrument being the subway train. But it can't be said that the perpetrator exercised dominion and control over the subway train. He didn't. He committed the assault but didn't commit possession. Thus, because neither crime is a material element of the other, and because these crimes weren't committed through a single act, Penal Law 7025-2 doesn't require concurrent sentences. Moreover, the possibility of consecutive sentences is consistent with good sentencing policy. A person who illegally possesses a gun should face greater exposure if they go then and take that gun and shoot somebody. Like in this case, where he had this gun and then he went and shot somebody in the face at point-blank range. Similarly, a person who shoots another should face a harsher penalty if they're doing it with an illegal gun, a gun they oughtn't to have been possessing. For these reasons, the order of the appellate division should be reversed and defendant's conviction and sentences should be reinstated.
Thank you very much, Ms. Worley. Mr. Weider?
Your Honor, the single most important question that was facing Frank Oglesby at that trial was whether he should testify or not. The Sandoval ruling at that trial would have told Mr. Oglesby whether he could get up there and testify or whether he could not. Because he was denied this hearing by the trial judge, he could not make an intelligent decision of whether to get up there or not.
Where did he say that to the judge?
Your Honor, this was not argued to the trial court. However, there was a motion made for a Sandoval hearing, and the Sandoval hearing was discussed in the pretrial proceedings.
And the judge said that he would adopt a different system or method, and there didn't seem to be any further objection or any registered objection at all by counsel.
Well, I think since counsel had brought up the point, had requested the Sandoval ruling, he had preserved the issue. When he said right to the trial judge, he had just conceded to the court's ruling, but I believe that the issue was still preserved.
That's exactly it. Didn't he concede to the court's ruling? The court gave a ruling, and instead of saying, well, Your Honor, I don't believe that's the proper ruling, or I object to it, he said right.
But, Your Honor, by raising the issue of Sandoval and requesting the Sandoval hearing, I believe that he had preserved his right there.
So as defense counsel, you join with the district attorney in agreeing, as unusual as that may be, that in this circumstance, that the issue was preserved.
No, sir, not at all. Well, yes.
Could have fooled me.
We agree with him that the issue was preserved. That's correct.
And that the appellate division ruled on the law because in your appeal to the appellate division, they exercised that authority as a matter of law.
That's correct.
Even though if you said it was not preserved, you'd go home a winner.
That's the part of my question where it says unusual as that may sound.
You want to take a moment to reflect?
Yes, I would.
Time is up. Really wasn't preserved, was it?
I would assume not, Your Honor. Upon reflection.
Please proceed.
And a lot of help.
I couldn't have chosen better help. With regard to the concurrent sentences, I believe that the law is quite clear in that where a assault is committed with a dangerous weapon, it is a single act, which Section 70.25 clearly states should require concurrent sentences. There's no way that my client or any defendant can commit an assault with a dangerous weapon without possessing that weapon. There may be certain ways that it can be done, pushing someone in front of of a moving car, but I don't believe that would come under the same category. But it's totally impossible to commit an assault with a deadly weapon without possessing that deadly weapon. I don't believe the legislature had trip guns in mind when the legislature made that up, and I believe the legislature would have made longer sentences, in fact, if they wanted these sentences to run consecutively rather than concurrently. So I believe it was the intent of the legislature when they wrote 70.25 that these sentences should run concurrently. Thank you.
Thank you very much.
Very briefly, Your Honor, the issue is preserved. First defendant makes this pretrial motion. On page 12, the court specifically asks him, do you want a Sandoval hearing? And defense counsel says yes. Later on, when the court then renders its ruling, says, well, I'm not inclined to make a ruling right now, he then asks him again, how are you going to treat that prior record? And the court then gives a ruling. I think that was a sufficient aid to alert the trial court to the issue, to indicate that he objected to the issue because he wanted a Sandoval ruling. In the alternative, if this court disagrees with us, this case should be sent back to the appellate division because they apparently believed it was preserved. And the question then should be presented to them about whether this is reversible in the interest of justice, given the fact that the evidence in this case was overwhelming. They never got a chance to judge that issue because they assumed that it was preserved and they reversed as a matter of law.
Ms. Bordley, do you feel at all uncomfortable arguing so passionately for preservation of an error of this kind?
It's an unusual situation to be in, but I do think, in fact, it was preserved. The trial court was alerted. The defendant wanted this ruling. He's always maintained that he wanted for the ruling, for the reason defense counsel suggested, because it had some effect on his decision to testify. Thank you.
Thank you very much, Bordley. Thank you very much. Board of Education, Monroe-Woodbury versus Weider.
Ready in court, please.
Mr. Adelson? No question here, but that this is for the advancement of religion, isn't it? Setting up a separate school?
Before I start, I got to ask you, can I have about 5 minutes for rebuttal time, because I may need it, given the record. I don't think so. And I recognize that that's the issue here.
Mr. Anderson, before you go on, if I may, would you want to make a motion for leave to appeal just in the event that the automatic leave is not considered to be that automatic?
Yeah, as a matter of fact, if Your Honors had brought up that issue, I would have asked you for permission for leave to appeal if you brought up the issue and said, I mean, quite frankly, I'd like to treat that issue if that concerns you first, and maybe that'll lead us into whether this advances religion. Cohen and Carger, our Court of Appeals book on page 268, 269 is the section I cite and rely on for saying this is a constitutional question directly involved. And by that I mean you really can't resolve this issue without reaching a constitutional impasse. And the impasse is whether or not it advances religion, as my adversary would argue, or whether it inhibits religion, as we would argue, not to give us the relief we're seeking.
You have to have a right. You have to start somewhere with a right before you get to the constitutional issue, though, don't you? And your rights here are all dependent on the statutes.
Yes, that's true. But I think once any government...
Why isn't it a statutory question, not a constitutional question?
Because I guess the way Cohen and Carger looks at it, first you have to decide the issue of statutory construction, and then you get to the constitutional question. The issue is, where do you get special education if you're someone who is attending a parochial school?
You can't very well bootstrap yourself into a right to this special education because of the free exercise clause, can you?
Yeah, I think you can. I think there are other issues which are not addressed in this case that can come up on this level. I mean, this could be an equal protection violation. This could be a violation of the right of handicapped children to special education. There are various other types of arguments.
Excuse me, nobody's denying handicapped children special education. problem here, there's a religious problem here, is there not?
Absolutely.
How about the state constitution, Article 11, Section 3?
Well,
Which says you can't aid directly or indirectly any religious group.
Yeah, but that's one of those constitutional provisions like the impairment clause and...
That knocked out a whole constitution in 1967 because of that Blaine Amendment.
Yeah, but there's plenty of things that are done in the state of New York and in other states that aid religion, and we all know it. I mean, the notion in Woolman versus Walters, which is one of my favorite cases to read on this subject, says you can pay for textbooks and give them to the people the children in the parochial school, and that's fine. And you can't give the parochial school maps. Obviously, distinctions are made. We all could argue that's indirect aid to the school, but somehow that's crossed that bright line the court has drawn. Now, when we get to the neutral site issue and getting back to the statute, I think it's pretty clear we're entitled to these services. The statute, why it was enacted and said what it said, is really kind of a mystery to me. I have no legislative history. My adversary assumes some legislative history, but I don't think he really can point you to anything to support what he says is what was intended. I think the statute was intended, as the Education Department says it was intended, which is if you were attending a parochial school and you wanted special education in the public schools, you could invoke the statute and go into the public schools, and that would be permissible. You wouldn't have to sign up and register as a public school student. That's the way they interpret it in the letter. The board here disputes that.
Mr. Edelson, you say you have a constitutional right to receive these services at a neutral site?
Yeah, well, I think the neutral site...
Well, what is the source of that? What is the source of that
constitutional
constitutional
the source of it is the notion that has developed in a number of cases, Woolman versus Walters is one of them, that when a state is giving services to people who are in a parochial school, where do you give the services? And there was a time when people thought that it was permissible to send teachers into the school, and that early on began to be struck down as involving excessive entanglement. The teachers would be there, affected by the religious institution. And in Woolman versus Walters and in other cases, the notion of neutral site has come up. It came up in another case I cite called the Wheeler case, and they describe there are ways to accommodate this. Use a neutral site.
Yes, but how does the fact that a neutral site is a permissible place to receive these services give rise to an affirmative right that you claim to receive them there?
Well, I think the reason it comes to that is because if you don't do that, you force people not to take the services if they choose not to send their kids out of the school that they've chosen and into the public school. And the argument, for example, the argument of the amicus for the school boards, they argue that this is the classic Bowen versus Roy, which is the case involving the Social Security number and the father of the Indian child who says, I don't want my child to have a Social Security number, it's robbing her spirit. And the court comes down and says, there are instances when the government will say, you have to make a choice. Do you want to receive the benefit? If you do, you've got to do certain things.
That might be another argument, an equal protection argument, or some other basis for affirmative relief. But your argument is solely on the First Amendment, isn't it?
Yeah, mine is solely on the First Amendment. And that's because, you see, you say, to come back to where do I get the right? You're right, it is an option. And it's been stated as an option, and I won't deny Woolman versus Walters certainly gives it kind of, as courts do. They don't write it as a definitive statement. They didn't contemplate what was coming up here. They didn't contemplate, excuse me?
Well, those are cases where the municipality or the government has chosen to provide certain services. And the action in they're deciding to do it is questioned.
Well, I'm not sure.
Here you're seeking to compel the government to do something that they don't want to do.
No, I don't think so, Your Honor. In fairness, Woolman versus Walters involves a whole series of things. That was the state of Ohio giving, by the way, Judge Titone, $88 million annually to the Catholic schools, essentially, in the state of Ohio for all sorts of things, because that's what we do here, and then we draw these lines as to what's permissible and what's not. But
I don't know if their state constitution is the same as ours.
I think ultimately we come down to the same kind of thing. we do. I mean, all states prohibit any form of direct or indirect aid, and then in my experience, I can't say I know every state's constitution, but they all have some prohibition against this type of direct aid. But to get back to your question, when you're dealing with, for example, Chapter 1, which is remedial education and various other things, the reading services that were in the PS-16 case in Williamsburg, which is cited in briefs by both sides, there, the solution that's been picked up is to bring a bus up to the school. And there are buses sitting outside of all the schools where remedial education is given. Sometimes it's a van, it isn't even a bus, it's just there. The kids march out of their school into that and get the services. It's money that's given by the federal government for remedial education, and the mandate is to see that everybody in that state gets it, because the government recognizes that if those children weren't in private school, in parochial school, they'd be in public school, and the government would be paying an even greater tab for that. And so they provide these facilities. This is the same kind of case.
Yes,
this is a case where...
My point is that Waldman was a case where the funding was being questioned, the constitutionality of what the government was doing and giving.
Yes, it was. You're right.
Here, that's not the case. Here, the government has said, we won't do this except under certain circumstances, except if they come to the public school, then you can have it. And the effort is to make the government do it. Isn't there a fundamental difference?
There is in a certain sense, but in another sense, it's a distinction that I'd like to share with you, which is that in the Waldman case, it was the state of Ohio. Here, it's the federal government, and here, the question is, the federal government said, disperse this money to the public schools, and the state government is saying it too. And the question is, does a particular board of education say, no, we're not going to do it this way, you must come into the public schools? You might ask me, what does that mean people are doing other things? I don't know. The record is unclear on this subject as to how this is being done around the state, and my adversary will tell you, we can discuss it. People are making accommodations, people are trying to resolve this, which is what the case is all about. The money is there, the mandate is there, give special education to handicapped children, they desperately need it, they go to parochial schools, and the question is, where do you get it? Do you make them? Does anybody have to take their child out of, be it a Hasidic school, or a Roman Catholic school, or a Protestant school, and bring them over to the public school to get something which everybody's entitled to?
Well, Mr. Anderson, you take great comfort from Waldman, and you read Waldman, and they continually speak in terms of this determination not being on a religious basis. And yet here, the mixture of religion is the sole factor. And if that's the sole factor, doesn't that take it away from the Waldman concerns?
I'm not sure I understand
Well,
what you say.
at the outset, we note that in its present posture, the case does not properly present any issue concerning the use of public facility as an adjunct of a sectarian educational enterprise. That's one observation they make. They talk in terms of the unit will depend on the distance between the public and non-public school, the safety factors involved in travel, and the adequacy of accommodations in public schools and public centers, not on a religious basis.
I think we have the same situation here, though. I mean, we're only highlighting it here because we're talking about a particular religious group that has expressed their religious preferences to be separate, but it's no different. This is still non-sectarian education.
They want it separate because of the religious beliefs.
So do the people in Waldman. Absolutely. They don't want the services. They don't want to send their children into the public schools. They chose to send them elsewhere, and that's what the neutral site is all about. I don't think we're talking about religious education here, and I don't think we're talking about there being any opportunity for mixture. But I'll go directly to the issue. I mean, I will say my adversary has raised this. There was even a motion to resettle the order below. Question of whether or not this facility is going to be used separately for one group or a mixture of groups. I think we're talking about a notion developing in the law, or not developing because the courts say it can't, that you're going to have to provide a neutral site for certain types of education, because if you make the people go into the public school, some of them are simply not going to get the services, they're going to choose not to, And that's a
How do
terrible
you
situation.
predicate that right, either on the free exercise prong or the establishment prong of the First Amendment?
Well, I predicate it on the free exercise because I think we all have the right to exercise our religion in a manner that allows us to say we don't want to send our children to public school. If I'm a Roman Catholic, maybe I don't want my children to go to school in an environment that will discuss abortion in a favorable light. If I
Well,
am
fine, then you set up a parochial school and you send your children there.
Oh, sure, and then you will lose the opportunity for your child to get special education, which is funded by your tax dollars.
Mr. Adelson, is it clear that at a neutral site there would be no limitations or restrictions, whatever,
I'm not sure of the nature that you mean.
in the way the services were rendered? Is it clear that the sexes of the children would be mixed and that the neutral site would be open to other members of the public?
Well, yeah, I can answer this. There's two questions
Or
there.
would the same restrictions apply?
No, our client has conceded on the record that as far as handicapped children in the Hasidic community, the Satmars here, that mixing of the sexes would not be an issue for them. And they've said that that's on page 438 of the record. Would it be available for other communities? At the same time, I'll answer it in a different way. Does it have to be? I mean, if it's a facility where, for example, you need an hour or two with each group, why does each group have to be mingled together? Why can't it be used at some point for the Hasidic community, at another point for a Roman Catholic community? That's an accommodation that I think could be made without any difficulty, unless someone feels compelled to say, no, we must force people to mix together. And society teaches us that that doesn't work.
I'm just trying to understand the question you're putting to us when you ask us to review this, the suggestion that these services be rendered at a neutral site. It becomes material to know whether you propose that this be a public facility or whether you propose that the same limitations that exist at the school be imposed on the neutral site.
I am saying it doesn't become a public facility. I'm going to go directly to that. In the appellate division, we argued about this a lot, and
I'm sorry, I didn't hear you
I will
clearly.
say it is not going to be like a normal public facility. It's not going to be another public school.
Therefore, you see, that's the same thing is troubling me, because I think it begs the question to say it's at a neutral site if, in fact, it's at a sectarian establishment directed by the government, because that's what distinguishes it from Woolman, where they may be providing secular services here, but they're providing them, and the government is doing it at a sectarian site under sectarian arrangements based on what you just said as well.
It's a very hard distinction. It's easy in the bus case. I hope you feel that way. If you bring a bus up to give people remedial education, which is what they do now, the kids go in and do reading or other types of education in the bus. There's a neutral site. It's not on the premises. It's not run by the people who run the religious school, and the government sends in the teacher. That's the distinction. When you talk about building a separate facility, it becomes a harder question. I don't know if it's within the power of this court to resolve the precise parameters of what that facility is. But what I'd like this court to be able to do is...
You want it to be separate, and you want it to be equal. Sounds like you're going to be relying on Plessy versus Ferguson.
It does sound like that, doesn't it? It does. It's got to be something less than sending your children into the regular classes of the public school, but it also can't be just another facility that the religious school runs with the state's money. Clearly, it can't be that.
Thank you very much, Mr. Adelson. Right?
Thank you, Your Honors. If it walks like a duck and it talks like a duck...
Oh, no, we left that one already.
We respectfully submit that you properly identified the duck, Your Honors. Clearly, Judge Green's order was unconstitutional. There was no secular purpose for it. The blanket directive to establish a mobile unit proximate to Beis Rachel in a village consisting exclusively of Satmar Hasidim had only one purpose. It violated clearly both the primary effects test and the excessive entanglement test. There can be really no dispute, but that no secular considerations served as the underpinning for the decision. As we analyze the facts, Your Honors, the issue in this case is not the neutral site. The issue in the case is the degree to which a Board of Education can be compelled to accommodate even to sincerely held religious beliefs. And we would respectfully submit that the Supreme Court's decision in Bowen against Roy is dispositive. Clearly, the petitioners, clearly the appellants have a right to believe and profess as they do. But clearly they cannot compel government to conduct its own internal affairs in order to accommodate to that belief, where that accommodation would have the practical effect of compelling a violation of the Establishment Clause. For the Board of Education to establish a so-called neutral site, which I respectfully submit is the large duck, right next to Beis Rachel, for no reason other than the socio-cultural and religious preferences of the Hasidim, would be tantamount to sanctioning serial neutral sites next to Lutheran schools, next to Roman Catholic schools, next to Hebrew schools, and be totally violative not only of the federal but also of the state constitution. Clearly, Article 11, Section 3 is involved as well. What is not involved is the Equal Protection Clause, because at no juncture was it raised or was it imposed. Now, Woolman clearly is not authority for the proposition that Judge Green had the authority to direct us to establish this so-called fictitious neutral site. In Woolman, in addition to the Chief Judge's quotes, the court made it very clear that the neutral site must be at a location which is neither physically nor educationally identifiable with the functions of the parochial school, and in which services are offered under circumstances which reflect religious neutrality. That clearly does not identify Beis Rachel as it's described in the record. The annex is physically annexed to the main building. It connects by a door into the main building. There are clearly mezuzahs on all of the doorposts. There are clearly religious instruction being given in contemporaneously in surrounding classes. It was never Judge Green's intention to mingle Satmar and non-Satmar children. And despite the statement that a representation appears at page 430 of the record that the Satmar would be willing to allow children to be mixed without regard to sex, that representation is at 100% variance with the affirmations of Menachem Friedman and of Joel Rosenshine, and of the treatise which appears in the record prepared by Professor Reuben, each of which strongly testify that by making the Satmar child familiar with the world in general, it will make him or her an outcast among his or her peers.